On July 13th, the three sitting commissioners of the SEC adopted some amendments that really were incremental changes to the procedures that the SEC uses for its so-called in-house court, that is, its administrative law judges. Specifically, the amendments dealt with the number of depositions that a defendant or a respondent gets to take in preparing for trial before the SEC, the amount of time that the defendant gets to prepare the case, and even some basic items about when you can actually file a so-called dispositive motion, that is, a motion to dismiss, a motion for summary judgment, to get the whole thing over before trial. So as you'd expect, the reaction was varied, depending on who you talk to. Certainly among the defense bar, it ranged from, at the very best, underwhelmed, to far worse than that, highly critical of the SEC and its crowd. Well, I think the lack of enthusiasm among the business community and the defense bar for the amendments is that the SEC simply didn't address what has been the #1 criticism of the process, namely that these cases are tried and adjudicated and resolved by in-house ALJs. And that's a fundamentally different system than the federal court system. These judges don't apply the federal rules. They don't apply procedure that's available in federal court. And disputes aren't heard by a jury. Instead, it's viewed essentially as a stacked deck against defendants with an in-house court. Well, certainly the amendments as they were adopted are incrementally better for the business community and for defendants in SEC matters. I suppose the SEC could undertake greater reforms. Certainly the business community would like to see that. But at this point, I think the debate's going to continue, and it's going to continue outside the SEC. People are going to continue to challenge the constitutionality of the process in federal court. Congress is going to continue to make noise about what at least some members of Congress perceive to be an unlevel playing field. And the defense bar will continue to challenge the process when actually within it.